Okay, can you hear me? I don't have a quick mouth, but maybe the people in the back can hear me better with this. So welcome to today's training on using violence risk assessments for court. First, I'm going to introduce the CME event. Then I'm going to introduce Dr. Feibusch, who will introduce our speakers for today. So this is a 3-hour training, good for 3 CME credits. Everybody's received the flyer. The link to the survey is in the middle of your flyer. That survey will open at the end of this training once I get upstairs to open it. And then it will be open until August 3rd. So please make sure that in addition to signing in, that you do the survey, because those 2 things are how you get your credit for today's presentation. So we do have a disclosure to make. Dr. Jackson is a consultant to and involved with research and clinical trials at various companies. Those relationships have no relevance to the topic presented today and will not be part of the discussion. Dr. Gaglietta does not have relevant financial relationships to disclose with ineligible companies whose primary business is producing, marketing, selling, reselling, or distributing healthcare products used by or on patients. So when you do this survey, please be sure to indicate that we made our disclosure statement. With that, I'm going to turn it over to Dr. Feibusch, who was our former medical director for the division. He's back as a consultant doing various things and working with CARP. So now, please welcome Dr. Feibusch.
Hey, everybody. Thank you. I have to manage my phone, I can't see anything, reading glasses and a mic at the same time. So I've been asked to do the introductions today. I'm going to start with Dr. Gaglietta. Dr. Gaglietta is an associate professor of psychology at John Jay College of Criminal Justice, City University of New York, where she served as director of the clinical psychology PhD program from 2005 to 2013. Dr. Gaglietta is a researcher and clinician specializing in the application, adaptation, and dissemination of empirically supported treatments to forensic and correctional settings. Dr. Gaglietta was one of the principal investigators of an NIMH-funded randomized controlled trial on the adaptation and use of DBT for interpersonal violence. She has studied and published on the application of DBT to psychopathic offenders and the use of DBT in jails and juvenile justice settings. For the last 15 years, she has developed specialized behavioral treatment programs in a variety of settings. Dr. Gaglietta trained and consulted internationally on the adaptation and application of dialectical behavior for juvenile justice settings. She has also conducted training for New York City police officers on communicating with mentally ill individuals and hostage negotiations. Dr. Gaglietta has appeared on CNN and Court TV and has been cited in the New York Times, the Washington Post, Time Magazine, and other media outlets. I've known Dr. Gaglietta for a number of years, and we're lucky to have her here. And we also have Dr. Jackson, who I have also known for many years. I met him probably about 30 years ago, right, Dr. Jackson?
And 3 years ago.
3 years ago, yes, 3 years ago. So as far as Dr. Jackson's biography, he's one of the founders and owners of the Neurobehavioral Medicine Group, which is an outpatient psychiatric treatment center in Bloomfield Hills, Michigan. Dr. Jackson has dedicated his medical career to caring for adults, adolescents, children, and families. He has treated high-risk groups, including those who are incarcerated, and has gained recognition through his various presentations. He is also extremely dedicated to various research projects focused on the latest research and potential treatment options for a variety of disease states, including schizophrenia, bipolar disorder, major depressive disorder, autism, ADHD, and movement disorders. He has also served as a senior psychiatrist for the state of Michigan Bureau of Forensic Psychiatry and the Department of Corrections for over 22 years. That's where we met. Do you still work there?
I retired.
Okay, so he is retired from the state. Dr. Jackson attended undergraduate school at Michigan State University in East Lansing, Michigan, where he graduated with high honors while majoring in physiology. Dr. Jackson obtained his medical degree from Wayne State University School of Medicine. He completed his general psychiatric residency at Wayne State University and his fellowship in child and adolescent psychiatry at the University of Michigan. He is board certified by the American Board of Psychiatry and Neurology in adult, adolescent, and child psychiatry, and has added qualifications in the specialty of forensic psychiatry. He's an associate clinical professor in the Department of Psychiatry at Wayne State University and at Oakland University, and he is an assistant clinical professor at the University of Michigan School of Medicine in the Department of Psychiatry. Dr. Jackson has published several articles and has presented at international conferences, including the U.S. Psychiatric Congress, NEI, and the American Psychiatric Association's annual meeting. So thank you, Dr. Jackson, Dr. Gallietta, and if you would join me in welcoming them to the presentation. Thank you.
Guys hear me in the back? Yes? All right. So I wanted to begin, I know many of you, but some of you are new faces. I wanted to begin by talking about why this training now, where this came about. So probably close to 2 years ago, we were asked, myself and I was asked to convene a panel of forensic experts to look at violence and risk across your system. So separate from this training today, we did a comprehensive assessment, and the panel was a really amazing group of professionals. So Dr. Jackson was on the panel, myself, Dr. Lori Butts, who's an attorney and forensic psychologist, Dr. Virginia Barbariojo, who is a forensic psychologist, Dr. Alex Garcia Mancia, another forensic psychologist, and I believe that's everyone. And so each of these professionals are people who have a host of forensic experience in civil, forensic, correctional environments and special expertise in violence and risk assessment. So we kind of did a survey of inpatient violence in your settings and Klein, as well as the regional hospitals. We looked at discharge. We looked at your whole risk management process, which is kind of linked to SSPRC and CARP in your system. So it was very broad-based. And we were able to give recommendations about lots and lots of things that included everything from staffing and training for frontline staff. But the part we're going to be talking about is specifically the CARP and SSPRC. It's kind of the oversight system. And in any system that we work in, there's some sort of kind of checks and balances for risk assessment. And when we came and we looked at your system, your statutes were written in the 70s and 80s and not updated since then. So they predated the advent of most risk assessment measures and tools. Now your advisory bulletins had kind of put some of that stuff in. And so some of the recommendations I'm going to be talking to you about today are about bringing risk assessment up to date in your setting. And that's not to say that some of you weren't doing this stuff, but as a whole, as a system, your statutes and your practices didn't line up with best practices. And so we're going to be talking about best practices in risk assessment. And specifically, this training, I know there's a lot of psychologists here. Raise your hand if you're a psychologist. Okay. And if you're a psychiatrist, we're kind of segregated on the side of the room. Interesting. This was really designed for psychiatry, as psychiatry is functioning in your system right now, but it varies hospital to hospital. So at Greystone, the psychologists are doing a lot of testimony. That's probably not true at Trenton and Klein, from what I understand. But the psychologists are the ones that are at least taking most of the bulk of the work on the violence risk assessment reports that you use as a piece of this system. So you're all here. That's great. We're going to be talking. So some of it may apply more to one group than the other. But we're going to talk about best practices and specifically about your statutes and some changes that are coming to your statute. And we don't know for sure that they're coming. The public comment has come back and there have only been a few comments that Dr. Fibush and Marie Flory are responding to. So some version of this will be, is that fair to say, coming into effect. So we want to kind of alert you to some of the changes that might be coming. And again, those changes are specifically to bring things up to best practice standards. I should mention that this training was developed in consultation with Don Dunphy, who is your legal specialist. So all of this stuff is been kind of talked about extensively at your administrative levels. So the goals of this training are going to be talking about, we're going to be talking a little bit about treatment planning, because one of the things that we noticed that was hallmark about your system was that people would decide what they were going to do about a patient and then say, we need a risk assessment because the policy says you need risk assessment. So what's wrong with that picture? Anyone? Right? Like the risk assessment is supposed to drive the decisions about patients, right? Not the other way around. Like we think they're ready to go. Now let's go get a risk assessment that says they're ready to go. That's like fallacious and problematic in terms of logic. So treatment planning becomes a big important part of this because the whole reason we assess risk at the start. So there was no mandate in your system to do risk assessment for someone when they first came in, which is a problem, especially for your incline, your high risk patients, your chrome patients, because the basis by which we detain people in forensic setting in incline is the need for treatment. It's not a sentence in the same way that if they were convicted in jail or prison, it's demonstrated need for treatment. And so that means we have to know what is keeping them in here. What is the basis by which, what are the risk factors that are keeping them in CARP detained at incline? And then what are we going to do about those to reduce those risk factors so that we can move them to a less secure setting? So we can legitimately say that we've done our best and we can now move them to regional. Sometimes they could potentially be able to go straight from incline to community or to regional and then regional to community. So the idea is least restrictive setting that we can do, but you need the risk assessment to do that. Otherwise, what we're doing is just waiting, and time doesn't change risk. That's one of the things we're going to talk about over and over again today. So there's going to be an emphasis on treatment planning with this. And one of the things that is going to be a change is that the risk assessment gets moved up to the beginning when someone first comes in. But the other things we want to focus on is the quality of the court reports. There's been some, not just our assessment of the court reports as a forensic panel, but also from the legal specialists and the judges. There's been some criticism about the quality of the reports and the quality of testimony. And I know your system well enough. I've been in your system for a long time to know that it's not one-sided, that there are many problems with the system that prevent you from testifying effectively. The state doesn't often have, the county council isn't often as aggressive or assertive as the people that are kind of representing the interests of the patients, and that can be really challenging. And so Dr. Jackson's going to be talking about testifying and tricks for how to manage a system that is not optimal or ideal in terms of the testimony. Okay, so let's keep going. Okay, so the goal of some of these changes, a lot of this was piloted at Ancora, and the psychiatrists were saying that they felt incredible pressure from the system and the court. So for instance, let's say you have a patient you don't think is ready, you think they're high risk, but you believe that the judge, based on your past experience, is going to make this person SSPRC, CEPP, right? You guys have a million letters that other states don't have, and say that they're ready to go. And so what was happening is they were kind of thinking, well, if they're going to be CEPP anyway, why am I going to get slapped by the judge? Maybe I should kind of do my best to say, well, if you're going to send them out anyway, here's what you should do. And so what ends up happening there is the integrity of the forensic psychiatric process gets compromised by the pressure of the system. So we wanted to toughen up the regulations and give psychiatrists some hard information based on the violence risk assessment report that you can use to substantiate your testimony so that you're doing the best job you can in terms of presenting to the court the most accurate picture of risk. And the court will then make the decision. We are not the trier of fact. We are providing information to the judge who makes the decision. But we want to make sure that we're like actually doing an educational role and not just kind of rolling over, if that makes sense. So some of the things that we're talking about in terms of changes are going to be things that can then be cited in court. In other words, I'm obligated to use structured professional judgment based on the statute. Let me tell you about structured professional judgment. When the judge says, has he hit someone in the last 2 weeks? No, then let him go. When he's actually a sex offender and a pedophile. So hitting someone for the last 2 weeks has nothing whatsoever to do with his risk. Does that make sense? Okay. So we're going to talk about decreasing adversity when testifying in court, increasing positive experiences for the psychiatrist when communicating with the judges, and it varies judge to judge, obviously, and reducing areas for difficult cross-examination. Okay, so what are the responsibilities that you all have to the hospital? So I just mentioned this to address risk at the outset. So your system, when we looked at it, the system as it was designed is actually not a bad system at all. The notion of having a CARP committee that oversees, each hospital has an SSPRC that's going to kind of make sure that every team is doing a good job risk assessment wise. And most systems have something like this because every person on every team can't be an expert in risk assessment. But you know, most places have a small group of people who become really good at this, and they become really good at knowing the difference between kind of high, medium, and low risk patients, and really specialists in terms of how to mitigate that risk. What should your discharge plan say? It's not that someone can or can't go, it's that they can or can't go under different conditions, right? So you might have two patients with the same risk profile, but if one of them has a family member who's going to take them home and make sure they take their medication and provide social support and provide activities for them, that person is a very different bed in terms of success than somebody who's going to a group home in the middle of a drug infested town with a substance abuse problem. Okay. All right. So your system is that when someone comes in admission, people who are special status, they're high risk for one reason or another, are flagged. And your AV says that, right? And so what are the things that you guys know that make someone SSPRC? What would say, so everyone at Incline is SSPRC, so that's kind of easy for the Incline folks. But what about you're in a regional hospital, you're at Trenton? What makes someone SSPRC when you walk in the door? Anyone?
Extensive legal history.
Right, so legal history. If you're a Kroll status, you are SSPRC. Here's the one that confuses people. What if you had a Kroll, but that Kroll has expired? New Jersey is one of the only states, my whole panel was like, whoa, we've never seen this before, where Kroll, which is NGRI, not guilty by reason of insanity, expires. It has an expiration date. And after a certain point of time, you're no longer Kroll status, you're no longer NGRI, which means that there's no oversight over you. So it doesn't count in terms of criminal or procedural oversight, but it absolutely counts in terms of risk assessment. And you can't wipe that away. You stabbed someone 17 times and killed them. That doesn't go away just because the paperwork expired. But in your system, you could see why it would lead people to think that, oh, well, they're no longer Kroll, so they're not SSPRC. So once an SSPRC patient, always an SSPRC patient, unless the patient petitions to have that status revoked. And there is a provision to have that changed if you can demonstrate that you are no longer at risk. But that's I don't know, that's never been done as far as I know. Have you ever seen someone have it removed?
It's happened, but it's unusual.
So unusual,
Definitely has happened.
right? So having an extensive legal history, having an extensive history of violence, even if you don't have legal charges. We have some patients that were schizophrenic and very, very dangerous in their home, stabbed their family member, never a criminal charge. That's still an SSPRC patient because you guys have to decide, are they safe to go home to this family? Because if they go home and stab their mother to death, that's on us a little bit. So it's really about prior criminal history, prior charges, and violence history, whether it's legal or not. Yes?
I was gonna say, I think it's also to go to SSPRC to have a set of eyes on the case.
Yeah, I mean, and there's a provision that if a team is concerned about someone, they can kind of do that. In practicality, I've rarely seen teams do that because it invites a lot of extra paperwork and a lot of extra work. So that's an internal systems issue, but the logic of thinking about a patient this way, even if you don't make them SSPRC status, is crucial for every patient in your hospital because the basis by which someone's civilly committed is dangerousness to self or other.
Yeah.
So there has to be some consideration of risk, whether someone's SSPRC or not. But the reason we have this committee is because these are patients that people would worry about. There's something notable in their history that makes us their heightened risk compared to the average civilly committed patient.
You're a person that makes that decision if they are SSPRC, they don't have criminal charges.
The committee would. So the team would petition the committee and the SSPRC committee would say, yes, they should be overseen or no, they should not be overseen.
So only the committee, not like the chief of psychiatry, cannot say this is not SSPRC, would be based on.
But usually, it's either the chief or the medical director sitting on the committee. So the request comes up to the committee and my philosophy on it was, if you're asking, they probably need.
They probably need it, right? And it's very rarely that people have done this, again, because it invites extra work. But it's important, right? We have plenty of patients who are extremely harmful. We have patients who have no violence outside in the community. We have patients with borderline personality disorder who have no violence outside in the community, but inside have created tremendous harm to frontline staff or to psychiatrists, psychologists, social workers.
Yeah, but we usually do it, for example, sometimes there is a confusion. But our, what we do is that we encourage our teams to present an issue to us. We look at the case that we encourage them so that there is an extra eye.
Yes.
And we review it and then we send it to CARP. So
Right, wonderful, yeah. So this is just, it's kind of, and CARP is essentially kind of an SSPRC that is centralized, right? That would take information from each of the SSPRCs and decide whether things are moving appropriately. So one of the things we did comment on as a group was that the way it's been, CARP oversees every single case. And we have said that if hospitals are functioning well, that's probably a little bit of overkill, right? That you could look at a random assortment of them, or you could, but certainly like annual or yearlies might not have to go. High profile cases where they're going to be political or where you have special concern or they're particularly complicated, you can always benefit from an extra set of eyes. But how we would do that at this point, all of the cases go forward to CARP. Now the other, we're going to get to some of these changes, so I'll save this for then. But CARP, think of CARP as like the SSPRC that looks at each one of the regional hospitals, including Incline, which is not a regional. Okay, so the treatment team gets a patient, they must assess risk and then figure out what the treatment targets get prioritized, right? So that the treatment targets that get prioritized should not be the low-hanging fruit, like, oh, we need this guy to shower. That's important, we are going to get him to shower, but we want to put at least as much energy into the drivers of why he got hospitalized and what caused this guy to be violent as you know, so that the more mental healthy, traditional mental health type treatments. Our treatment providers have been really steeped in rehabilitation, in rehab, in psych rehab. Back when the kind of people who got hospitalized or anyone with schizophrenia who kind of had a little bit of problems living in the community. So if you look at what the census used to be at Trenton Psychiatric Center years and years and years ago versus now, it's completely different. So deinstitutionalization has happened such that you have a much more acute group of people than you ever had 30 years ago. In other words, it used to be one or two of those patients would have high risk out of all of them. Now, that percentage is much, much greater, which just creates a lot more stress on the system. That's unavoidable. That's kind of the way the world has evolved. But I just want to say that's why this process becomes really important and why our treatment teams weren't necessarily trained 20 years ago to look at risk. They were trained to look at, hey, what is this? Is this person taking their medicine and are they doing okay to live on their own? That's part of it, but that's a little bit unsophisticated for what we need at this point in time, given the risk to public safety that some of our patients actually confer. So here's the biggest thing. We're going to use contemporary science to provide information to the court in a timely fashion. So one of the other things we observed was that your timelines were really problematic. So I didn't mention that IST patients in your system, IST patients are all, incompetence to stand trial patients are all considered high-risk patients, SSPRC patients. That's not true in every system, and there's not necessarily a link between incompetence to stand trial and violence, but that's the way your statute reads at this point. So anyone who's IST also goes in this bunch. Okay, so I just talked a little bit about the purpose of SSPRC, but your actual NJSA 30 talks about establishing a mechanism to provide a comprehensive review of the treatment and management of these high-risk patients, right? So that levels of supervision, plans for less restrictive settings, decreases in structure and discharge get monitored, get eyes on, and we're doing the best job we can with science considering the risk factors. Okay, now you'll notice that there's this clause that you still have to comply with an order. So if a judge orders somebody discharged, you are required to do discharge planning for that person. But we do have situations where the judge cannot make clinical decisions. The judge can say, this person is ready to go, but you determine where they go and when they go. And so if you cannot find, so we have a whole bunch of patients that are very high risk sex offenders that in many states wouldn't be in the psychiatric system. They would be in a more like your STU. And those people may be considered CEPP by the judge, but you then have to find a place that will accept them. So if you can't, they end up in this limbo in between where they are CEPP, but you don't have to discharge if you feel you can't find a place that would provide enough security. So there are these extreme cases, and then there are some that are just like, you're not super happy that the judge made this person CEPP, but we're gonna have to go along with it, and we pile on management in the community as best we can. So I'm trying to get you to see it's not black and white, but it is about degree of risk and our communication. So the whole purpose of SSPRC is to make sure that we're attending to this, right? Okay, one of the things that's a change to 1036, a proposed change. At the beginning of this, everybody and their brother was on this committee, right? So you had originally director of psychiatry, psychology, social services, rehab, substance abuse treatment. I'm not sure who else, but if you've ever been in these meetings, they're kind of very big. And when we started to observe them, there were many people who had no idea what the purpose of the meeting was. They were just they showed up like any other meeting. And it sounded very much like a clinical meeting. He's taking his medicine. He's done he's done what he's supposed to do. We're okay with it. That is not a careful consideration of risk. Okay. And so we want to make sure that the people who are sitting on SSPRC, like certainly every team needs to be involved in every patient's decision, but the people sitting in an SSPRC are the ones that are supposed to be taking the information from the team and kind of overseeing the logic of level change, the logic of discharge, what's needed for discharge. And so it's a massive waste of resources to have every head of your department sitting in meetings for half a day a week. So if you don't need them, you don't have to. Now you can, if you feel that there's some reason and you want people in the meeting, you're always able to add more people. But what this statute change would do is it would say the only people that are required to be in the meeting are the medical director, the chief of psychiatry, the director of psychology, and director of social services, because that pretty much hits most of the pieces we need for risk assessment. You can call anyone else in, but those people or their designee, meaning that they trained someone, would be sufficient to kind of have oversight, right? In the eyes of what most forensic professionals thought about your system. So it's just reducing that number of people, but you don't have to. Yes.
So one of the themes that has evolved in SSPRC over the years is really a biopsychosocial component. For example, at DPH, we have based on the recovery-based model, which is very, very useful to have not only the social services that deal with the discharge process, but also the rehab people who are looking at overall the program. Like for example, the substance use component is very, very important. So we are able to get the first-hand knowledge how much this patient is involved in the substance use. And especially we have also pastoral services here, the issues related to grief, spirituality. So it really gives us a overall view based on the psychosocial component. I hear what you are saying, it makes total sense, but I also wanted to share how much we have benefited from different disciplines in the overall recovery of the patient moving forward.
Yes, but I would argue that that's treatment, right? And that all of that is relevant, 100% relevant. But what we noticed was that you guys gather information in these SSPRCs. Okay, so I'm going to say that again. You gather information. You say, what's he doing in substance abuse? What is his spiritual beliefs? Has he processed the death of this person? That is a massive waste of resources and time. You should not be gathering information in these meetings. Those things the teams should have gathered, and they should be written in the form. So we've created a much more streamlined SSPRC form where everybody should have input on the team, and the team then says that to this group of people who are only saying like, hey, have they covered all the bases? Are they missing anything? So I think that I don't disagree at all with the validity and the necessity of as much information as you can get about a patient. But the problem is the way you guys are doing it is really inefficient and very out of step with how most other systems do the information. The other problem with it is that we find that actually sometimes teams are making really well justified decisions, but they don't, it's not in the paperwork, right? It's in the meeting. You're chatting in the meeting. Then it goes up to CARP. CARP has no way of knowing what was discussed in your meeting if it's not written down. So then CARP will say, oh, you haven't considered this, this, or this, and kick it back to you. And then the team gets upset because they're like, look at all, we've done all this work with him, but you haven't documented it on the paperwork. So, you know, the old adage, if it's not written down, it didn't happen. So people have gotten a little bit like, it's easier to have conversation than it is to think logically and write it down, but we want that all moved to the team work, not to the SSPRC. At least in terms of if you want to be doing most efficient best practices. So that's one of the proposed changes is just a much more narrowed SSPRC group, and then a much more narrow agenda driven meeting. So rather than just kind of, we don't need a whole team. Do you realize that when we watched these, SSPRCs would meet and would hold up 3 or 4 or 5 teams waiting to call them in to ask them stuff that should be self-evident from the SSPRC packet. And so the problem is it's just ties up your whole hospital in many ways.
Dr. Gallagher, can I make one comment?
Please.
About the response to
You want the mic?
Sure. So I hear what you're saying. You know, this proposed regulation, if it goes through in this form, you know, like your director of pastoral services may be a really valuable member of your SSPRC team to train, but they might not be a Greystone.
Right.
Like you can have them. You're allowed to have them.
Yeah.
It's just not required. It changes the requirements for SSPRC. So there's no prohibition on it. It's just a change in who were the required members. That makes sense.
And one of the other things I think that is very, very fine, I hope that you will be able to weigh in on this forward is, so there is a clinical component that the psychiatrist, SSPRC and CARP, and then there is a legal, whenever psychiatrists are going into court. So some of the judges, they don't want to hear about SSPRC and CARP. They are making totally a legal perspective. And so I think that is also important that how our psychiatrists, when they go in the court, take that balance. I mean, SSPRC, psychiatrists are partnering with me. So I think that is something also needs to be, when Dr. Freibusch was here, he was very clear about all these things. That, you know, when you are making a clinical argument in the court, and whether you mention the SSPRC or not, but again, should not be totally or as that SSPRC is not negative. You know what I'm trying to say?
Yeah.
All about the clinical argument.
So you brought up a couple of really important points. So one is whether the SSPRC and the psychiatrist agree, right? That is one kind of piece that we're going to address. But the other bigger piece is that clinical forensic role conflict, okay? And one of the things we did talk about when we looked at your system is the fact that your psychiatrists are testifying about their own patients in court with regard to their legal status and their risk. That's not done in most places. In most places, there's an independent person evaluating risk. In other words, you can always, the psychologist on your unit can do the initial risk assessment because it's not a patient they have any bias or any experience with theoretically. If they did, let's say they had them on they were their therapist on a past unit, they likely would want to switch with someone else because you want that kind of dispassionate, neutral evaluation of risk. But the first one is fine. But then you shouldn't be treating your client for 6 months and then you do the risk assessment because what kind of bias can go in that? All kinds. Sometimes we're like, we've worked so hard with this guy, like we know he's going to be okay. Or he says he's going to burn down the place, but we know he doesn't mean it. We get our own little biases where sometimes we're attached to patients and their hard work. Sometimes we're sick of them and we want them gone. And we're like, he's fine because we can't take one more day with this patient. And so one of the things that I think the judges here, frankly, it's probably gonna go somewhere, so I'm gonna get in trouble for saying this, need education about, they don't want to hear from a neutral person. They want the psychiatrist who's treated them on the unit. And that's a problem because then you are giving them clinical information, and clinical information is relevant, but it's like this much relevant. There's many other things that are the risk factors that they need to hear about. And they're not understanding that those are the things that, you know, that they need to consider as triers of fact, not just the clinical response to treatment, because especially you're not targeting the right risk factors in treatment, whether he takes his medication or not, may or may not be very important, right? And we're gonna talk about all these little things like, oh, he's on a long acting and he's taking his medicine. Have you measured psychotic symptoms? If he was psychotic and that's why he stabbed someone and he's on a long acting, but he's still got all kinds of crazy psychotic symptoms about the government and KGB and all this stuff, you haven't done your job. But if you say to the judge, oh, he's taking his long acting, it's great, we've managed this risk. That's not good practice. All right, so we're gonna talk a little bit about that. And frankly, to be very honest, most of your SSPRCs sounded like clinical meetings, not risk meetings. I'm gonna say that my committee was really shocked that after listening to sitting in for these for months, I almost never heard the word risk mentioned once. Or even violence, very rarely. What got mentioned was whether he or she was doing what they needed to do, whether they were compliant with treatment, whether they were taking medication, but very little about the effects of the medication. Was it effective? Was it related to dangerousness at all? So we definitely, clinical is important, but it's not sufficient to do this. You have lots of clinical meetings. You don't need any more clinical meetings. You need a risk meeting, and that's what so the idea would be to narrow the focus of SSPRC simply about risk and manageability and treatability of those factors.
Dr. Galley, I make a quick comment on this too. I'm sorry to keep it.
No, please do.
So as far as like the treating psychiatrist testifying, it's not just what happens, for better or for worse, it's actually the law. Like it's required, and yes, it's a problem. They may not be the best person. And as far as the assessment process and violence risk assessment, you know, we're in an environment that there are limited resources. Sometimes you have to wear two hats, unfortunately, and we have to work through that. And part of the rationale for having SSPRC and CARP is to help cut through that.
Right.
A little bit and provide some checks and balances on it, because you know, again, you know, resources can be limited in this environment. So we have to work through that process.
And also, I guess that when we are looking at these cases, so the most important question is, what is driving this behavior
Yes.
when this patient is in the community?
Yes.
What are the real risk factors? And for example, I mean, if, you know, and risk factors are variable. It has to be pointed out one by one, how we are really mitigating that.
Yep.
And one of the most important questions that we want to ask, if the patient has 20 hospitalizations in last 10 years, what we are doing different this time to prevent this? If we are doing the same thing that was done in the past, which is something is missing. So the point that I'm trying to make, the treatment does inform. It is important in these meetings to discuss, because eventually it is the psychiatric symptoms that are precipitated into some other factors. So we just cannot completely
Right.
Separate these two things.
No, we can't separate them. And it's not just rehospitalization, right? We're focused specifically, this committee, it gives really good input into treatment and into reducing rehospitalization, but that's not really the purpose of this committee. The purpose of this committee is to protect the public and to protect the patient from new charges and to protect other patients from violence in this case. This is a violence one. So, you know, might have patients who are suicidal. SSPRC is not, you don't have SSPRC if you're just a suicidal patient. You're not usually going to be on SSPRC. You have other mechanisms to manage that. So I guess I really want you guys to think about SSPRC as honing in narrowly on violence risk. That is kind of the piece. Now, clinical absolutely impacts that. And when we talk about reduced resources and the need to do our own risk assessments, it's true that you guys are pushed and the statutes kind of push you in ways that may not be ideal for forensic practice. But there are ways around that, right? You can flip. You can kind of rotate where you take someone else's units and do their risk assessments and they do yours. Now, they still may want you to testify if you're the treating psychiatrist, but you testify based on a risk assessment that you did not do, that someone else did. And that doesn't take any more resources. It's just a policy thing that would be different. And that's one of the reasons for having the psychologists do the risk assessments, aside from their background and training in psychometrics and in kind of understanding risk, that they get specific training in that. So it doesn't have to be a psychologist. It could be anybody who's trained in risk assessment that can use these structured professional judgment tools. But in your system, given that the psychiatrists are mostly testifying, it's really nice to be able to testify and have something that's a little objective, a little more objective for you to rely on and say, this is what the team came up with using this tool, and I concur with this, or I don't concur with this, and here's why, and give your rationale. So just so that we know, the SSPRC, it is about balancing the patient's need for treatment and the safety of the community, right? So we want people to be treated in the community so long as they can safely be treated in the community. We don't want them to stay here if they don't need to, but if they do, we want to make sure they stay. Okay, so the treatment team is the one that's supposed to be making decisions about levels of supervision, treatment interventions, and discharge planning. So the way that your level system works is one of the things that's a little confounded. It's also in statute, one of the only states where the level system, level of supervision, is dictated in your own statute. And so what we observed is that level of supervision was assigned by psychiatry most typically based on a person's safety, whether they could be alone or not. Okay, that's one component of what your statute says you should be considering, but the other components that are in your statute are participation and engagement in treatment. So if you have a client who refuses to go to any treatment, but doesn't have any imminent risk right now, they shouldn't be level 3 in your statutory definition. Okay, not what we think, that's what your own definition, but that's not how it's practiced. Our recommendation was that teams and hospitals should be able to decide levels, not CARP, because you're closest to the treatment. And because some of that, as you get better, naturally, freedom is one of the consequences of engagement, successful engagement with treatment, right? In other words, you want to be able to be very nimble at moving or constraining freedom based on clinical presentation, which changes like this. So we really thought that that should be more of a hospital and a team-based decision, so long as we know that the teams are making those decisions well. So the SSPRC ensures that the teams are making those decisions well. But ultimately, one of the changes was that level changes probably shouldn't go to CARP, that CARP should be just about discharges. So we'll see whether that gets put into the final statute or not, but just so you know what the forensic panel thought. Okay, so here's the code changes that are going to specifically impact psychiatrists. This is the most important one, is that it used to be that you could testify on the basis of my clinical opinion. Unstructured clinical judgment, right? Your gut. That's how decisions were made when the statute was written. That's how decisions were made 30, 40 years ago. That's not best practice. It is not best practice to be like, I don't think this guy is going to be dangerous because I have a personal relationship with him. I think I've seen some growth in him. We know that when you make decisions based on unstructured clinical judgment, just gut, that they're worse decisions than if you use any. There's a couple of different types of tools that you can use, but that they all fall. The clinical, like just your own gut, is inferior, no matter who you are and how good you are. We just know that that's true. So psychiatrists now, the approach that the state has decided to use is something called structured professional judgment. And there are particular checklists, guidelines, tools that help you to do structured professional judgment, SPJ. I'm going to contrast those with some of the other tools that are still in your system and can be used, actuarial instruments. But we all can agree that we're not going to do just gut decision making, that we're going to use some tools. And the statute now requires that you not just use some tools, that you use SPJ. And HCR, the HCR is the tool that you guys use for SPJ here. Okay, the psychiatrists have to document CARP and SSPRC decision-making and CARP and SSPRC recommendations in your court reports. So you can't, even if you disagree with what SSPRC says, and no one's telling you how to practice, right? This is your license, this is your professionalism, but you must disclose to the court based on statute if SSPRC and your decision-making do not align. And then you have to provide the rationale for why. That's a change. It used to be that you could just testify and not mention what SSPRC or CARP said. Okay, so that's a big statutory change that's proposed. In cases where there is a disagreement with the risk formulation or the decision of a team or SSPRC, you have to include testimony about the actual risk assessment report that the psychologist has prepared and the rationale for your disagreement. And the basis for your decision-making should be the best available scientific evidence. Okay, so that means we need to know what the science says about particular risk.
So it takes the onus directly on this, from the liability point of view, for example, the SSP and CARP bring out of this totally on the psychiatrist.
No,
For
no,
example, if there's a disagreement in the psychiatrist
Yeah.
and SSPRC and CARP, and the report goes along with the psychiatrist. So my question is, what is the role of SSPRC and CARP?
so SSPRC and CARP could, if they wanted to, actually block a discharge. They could, theoretically. But if the judge was making the decision about where, like, so in other words, let's say a judge and a psychiatrist disagree with CARP, and the judge and the psychiatrist say the person can go, and CARP says they can't. The judge could order them CEPP or discharged, but the hospital would have to actually find the discharge plan, and CARP could say, that's not a good discharge plan. That's not an acceptable discharge plan. We can't live with that. So CARP is there to protect the liability of the hospital. I know that you guys actually have very little litigation here relative to other states. And in most states, psychiatrists are terrified that they are going to get sued for letting a violent person out. And in this state, people are terrified that they're going to get in trouble for violating a patient's rights and keeping them in. It's just a very interesting difference regionally here than other places. But what I would say to you is that the idea of CARP and SSPRC is to diffuse liability, to protect you, to say, you know, you will never be, you can never be, if someone commits suicide, you will not get penalized theoretically in the law for the person doing that. Because we can't predict the future 100%. Where you will get in trouble from a negligence point of view, and Dr. Jackson will talk a lot more about this, is did you follow the steps? And the best thing you can do to protect yourself from from liability is to say, I consulted with other professionals. So SSPRC, the fact that you take a case, you talk about the risk factors, and you have this, this set of considerations protects you as long as you guys are in agreement. When you're not in agreement, you have to have a good rationale, and you are kind of sticking yourself out there a little bit. So you have to have a good reason. And the whole point we're hoping is that those disagreements get resolved way before you go to court, right? So it's the conversation happens so that you get to synthesis and you understand, and then you have protection when you go to the courts.
I just wanted to be clear. So for example, hypothetically, there is a possibility that, the physicians are independent licensed physicians. We just cannot dictate them what to do. We can make recommendations. For example, if SSP and CARP have a difference of opinion and the psychiatrist makes a decision that this is the direction that I'm going to go. So I just want to be clear. And if we cannot reach an agreement, ideally it would be that SSPRC, CARP and the psychiatrist sit down and diffuse the situation
Right.
and suggest it. But in the end, eventually it is a psychiatrist's decision, and team would be coming up with a discharge plan or whatever it is. So in that situation, we just leave up to the psychiatrist.
I mean, the psychiatrist is the one who has to testify in court to what they think. Now, the question, this is kind of more a question for your legal specialist, John Dunphy, and we did raise it, but the issue would be indemnification. Would you be covered by the state if you disagreed with the hospital policy? And my best understanding of this, and I want you to check this with him, right, is that if you follow all the policies and procedures of the hospital, you do not have to agree and you would be covered. But here's where you would not be indemnified. If you don't follow the policies and procedures. So if you go against the AB, so let's say that there's an AB that says you have to send the case to SSPRC and you just didn't send it at all. The team never sent it. You just went to court and you testified, and that guy goes out and stabs somebody. I don't think the state has to then defend you because you didn't follow the policies and procedures. So it's not about your decision making, you understand? It's about, did you follow the steps that the AV says you need to take? Was that?
Yeah, I can comment on this a little bit. And some of the things that Dr. Galliard has talked about, they're not new. Dr. Eilers clarified this in a memo, I think it was maybe about 2006 or 2007, but it was always the case that the testifying psychiatrist is always expected to give their opinion. Like, to what they think in court, they are required to do so. There's no suborning of perjury. You are required to give your opinion, but you're also required to go through this process. And we've had it in the AV long before any proposed changes, that if there's a difference of opinion, that you let the court know that there's a difference of opinion and that you're talking about. So this is not new. It's just what's new is potentially changes in the statute. What Dr. Galliard is talking about as far as whether the AG will cover somebody or not, I can't really answer that question, and I don't want to go out on a limb. And I think it would put you at higher risk if you haven't followed the process. But I would not say that they're not going to cover you. The kind of things that I know that they won't cover people for is like what's called an intentional tort. Like if
Punch a patient.
yeah, punch a patient or do something, those things they may drop, they may say, we're not going to cover this. I don't know if this falls into the same paradigm, so I really can't answer that. And my guess is that any case would be looked at individually.
Yes.
I know you said that Don Dunphy, who's the legal, I guess, person looking at everything, has looked at this. So I know in the past, whenever in court we've gone to testify, the court does not want to hear what the SSPRC or CARP has said. They want to hear from the clinical psychiatrist, what is your plan moving forward?
Yep.
And it's not always going to be CARP agreeing, because they might not be made CEPP, they might be given a 48-hour discharge because there's a place to go and SSPRC and CARP didn't agree. So if you send this patient out and something happens on the outside and you didn't follow those rules, then again, those are things that are falling back on you. So is now Ford going to be aware that we're going to be giving recommendations and discussing SSPRC and CARP in?
Yes, we are trying very much to get some face time with the judges because the judges need to understand the risk assessment. It's very clear that the judges aren't understanding contemporary risk. They don't understand the factors. In most states, there's judicial education every year about these kinds of things. And so we're trying to get that in front of them and also to have the legal specialists convey some of this information. It is important that there's even been some talk of like, should these things be appended to the court testimony so that the court can see them? So this has not been decided as far as I know in your administration, but the point is the logic of a violence risk assessment, a kind of formal risk formulation is what has to go to the court. And that is ultimately like up to you to do. The violence risk assessment you get from the psychologist kind of gives you helps you to think it through. And it, by the way, it shouldn't be done alone by the psychologist. It should be done as a team, right? Psychologist, you could sit, and the tools that we use, the HCR is meant to be done truly where somebody reads the chart, but you literally talk about, hey, here's what we see. And particularly with clinical changes, right? Like first one to the last one. Hey, we've seen him do this, we've seen him do that. And we need everybody, including the frontline staff, right? Especially with your real antisocial guys, they can kind of come into come into the treatment team and say, I'm going to not take, I'm not going to use drugs in the community and I've learned my lesson and I'm going to do all this and that. And then it's really nice when you know that the night before the frontline staff saw them saying like, I'll get you some of this and I've got this coming in and I'm going to sell this and I'm going to do that. And so when there's inconsistent information, that needs to come to team. And so you're always going to try as a psychiatrist to represent all the information. Like you are the one that kind of talks about anything in the record. And the problem here is that a lot of stuff that should be in the record doesn't get put in the record. And so then they will say to you, like, you can't testify about that. Where is it in the record? So it has to be your clinical experience or something you heard from somebody in the treatment team, in your treatment team work. A couple other things is just, this is a statutory change that now you have to do SSPRC risk assessment at admission, not just yearly, okay, not just before discharge. And again, that's the rationale that like, because we have to develop the treatment plan has to be driven by the risk. That's pretty straightforward. Okay, so treatment planning, it forms the basis of the multidisciplinary treatment plan. If you have somebody we have these cases all the time where somebody is secure and inclined and goes to a less restrictive setting and then does something really problematic. There was one case that I looked at where the risk assessment from Anne Klein was quite strong. It identified the risk for sexual predation. And the receiving team didn't pick it up and didn't put that in any kind of safety plan, risk mitigation plan. And the person had non-consensual sex with someone who couldn't consent. That was foreseeable, right? Kind of warned the person and then they didn't do it. So we want to improve those sorts of team to team links. And that when you get that initial violence risk assessment, if you see there's a high risk for somebody going into someone's room and having sex with them, or there's a high risk for somebody getting matches and setting fires, that there's a special plan in place from the day the client walks in. Hey, everyone, this person cannot have access to matches. If they go outside, they shouldn't be able to go outside unless you've assessed the risk for fire setting or something else. We must target the drivers of violence as primary things in the treatment plan. It can't just be something buried down at the bottom. It has to be like, we can't do everything all at once. The nice thing is we have so many people who can do treatment that you can parse out like, hey, the dietitian can work on this. Someone else can work on this. But as a whole, we're not just treating like wellness for everyone. This isn't a spa. We are treating violence risk. And so that has to be like front and center in every single person's mind and in the treatment plan. It has to jump off the treatment plan pages. We have to treat violence in the community. Right? So what was the reason this person was violent in the community, which might be suppressed here? So you have a person who's a pedophile, has no access to children or child pornography, hopefully, in your setting. And you're like, well, he's not doing it here. We don't have to treat it. No, your obligation is to treat sex offending behavior because that's what was high risk behavior in the community. But you also have to treat violence risk in here, right? If this is people are hitting people or hurting people. So you have this twofold responsibility and the treatment plan must address both of those. So you can manage risk without treating it, right? So we want to manage until we treat and then develop the best treatments we can. I know that one of the problems is that you don't have great treatment, like anything. You couldn't just like say, hey, I'd like this person to have this, this, and this. I want CogRem, I want this, I want that, and have it be readily available. The system's working on that. But at the very least, if we articulate what is needed, we can approximate it, even if we don't have a person who's an expert in sex offender treatment. Any qualified psychologist, licensed psychologist could pick up a manual and deliver a treatment based on a manual as best they can. It may not be perfect, but it's going to be far better than ignoring the variable altogether, saying we don't have sex offender treatment, so we're leaving that off. There's a question over here, yeah.
Those changes saying that everybody comes in into this assessment, like, so maybe for Anne Klein, does that include all our IST?
So, okay,
No.
so because there's a problem with the notion that everyone who's IST is violent, like there is no clear correlation. You can use your judgment based on the crime someone's alleged to have committed and their violence history about whether you need something like sometimes people come in and they've been violent in jail and you need something quick and dirty just to put a risk management plan in place so they don't kill anyone while they're on the IST unit. But no, would you need a full like HCR on no, and it's kind of problematic because it goes into their record. So you don't want an HCR in an IST patient's record for ethical reasons, right? In other words, the only issue that you are asked to do at Anne Klein, if someone is an IST patient, is to determine whether they are fit to proceed with court. That is your task. It is not your task to say, hey, he did this in the past or that in the past. So you don't have to treat sex offending behavior on an IST unit. Okay, because theoretically that person will either be found guilty or not guilty, and then eventually that we will have that. You're just there to answer the question of are they fit for court. And the only other little wrinkle in that is if you need a violence risk management plan, mitigation plan, just to keep your staff safe while you're assessing that person, you might need to do that more quick and dirty. But that's more of an imminent risk thing. That's different than an HCR. You wouldn't need a long HCR report or anything like that. Does that make sense? These tools are there to make your job easier. They're not there to add labor. So we don't want to have unnecessary documentation or documentation that could be harmful. All right, I'm gonna go super quick through this because I really want to make sure that you get to the testimony piece. So these are just a few things we noticed in terms of treatment, where treatment goes wrong. There's a therapeutic pessimism. We know we can even treat psychopathy. It's not easy. Most people don't enjoy it. My lab did a lot of research on treating psychopathy. And the data is solid in that the more treatment someone's in, the lower it does lower their risk. The problem is they start out up here on risk. So you can do tons of treatment and just get their risk from here to here, and they're still super high risk for many of them. So we're not saying like we could fix them, but what we're saying is that treatment works, and there's really almost no one that we should be like throwing out being like giving up on that. Okay, even for really treatment resistant patients, psychotic patients, we are gonna constantly be trying new things that come out, or constantly be kind of having case conferences every now and then at the very minimal yearly to see what's changed, what could be different for this person. But when we have therapeutic pessimism that nothing's gonna work anyway, we don't even bother to put it in a treatment plan. So case in point, personality disorders are almost never documented on your diagnoses. So the problem is we don't document it because we're like, what can you do with that? We do have effective treatments for personality disorders, whether you guys have them in your system or not, it's separate. But when you don't write it down, then it comes to the risk assessment. And the reason this guy is so high risk is because he's antisocial. He's sky high on psychopathy, but it's nowhere in his record. So now you go to testify and you're like, well, he's psychopathic. Well, where does it say that? So you want to make sure that we're accurate. And that I think one of the reasons we don't document some of this stuff is because we think, what's the point of it? It doesn't work. Or we think, oh, he belongs in jail, not here. So we don't treat it. He belongs in jail. Maybe so, but if you have him, you have him. And we do the best to treat what we have. Okay, the other thing is failure to manage safety adequately while treating patients. This is your biggest dilemma. It's like, how do you keep people safe long enough so you can treat the stuff, right? So you get a really out of control psychotic person who's aggressive and violent. You need to contain that person long enough and separate them so they're not punching people long enough for you to get the medication in them to stabilize them. That's always been a bit of the challenge, right? But it's getting harder and harder because seclusion, we don't want to use seclusion when we don't need to. So it's not an easy thing. That is a challenge, and you have to kind of do that. But when we don't manage safety, people get hurt so much that teams get burned out, and we end up doing more like what I call bus therapy. We just say, hey, this team can't take it anymore. We'll just give them to another team. And then that team gets beaten up, can't stabilize them. So we want to do our very best to be creative with risk management. That includes, sometimes it might include seclusion or separation, but we can do it with lots of other things, with distraction, with separation. We have like one of the things I do with some of our patients that have targeted a particular person is we give them like a fake restraining order in the hospital. You can't be within 200 yards of this patient. So that's not seclusion. That's not violating any of your policies or procedures, but it requires your staff to know this person is targeting her. And so if you're anywhere near her, staff need to kind of move you away or move that patient away, which is often much easier than moving, the offender. The other thing that is really problematic is under treatment, failure to IMAR patients, right? So a patient is taking a subtherapeutic dose of something that is not touching the symptoms that drive their violence, but they're complying. They'll say to you, I'll take this, but not that. Can you get me some of this? I like that. That is not, right? It's not adequately addressing risk, but it's a much harder argument to make to the IMAR committee or to somebody to say, well, he's complying, but it's not working. And so the argument has to be, he's psychotic and dangerous. So whether he's complying or not, he's not complying with the treatment we think is going to help to reduce violence. So that's the argument we have to make. And I think sometimes people are so afraid they're going to get shut down, they don't go for it. And then people languish with high danger and high risk. Sometimes we just treat the wrong things, or we treat with the wrong treatment. So we saw a sex offender, and what people were doing was sensory therapy, right? Like with an OT. And that was what was documented as decreasing risk for sexual offending. Oh, he's working with the OT on sensitivity, self-soothing and things like that. Do you guys think that would work? Is that written anywhere that that's an evidence-based treatment for sex offending? No, so we have to make sure that the treatments we map on actually have some evidence base for decreasing the problem we're trying to get rid of. The next big thing is allowing time to elapse, right? He hasn't done it in this long, therefore, we think his risk is reduced. Especially in a controlled environment. The fact that someone hasn't done something doesn't mean anything. We have patients who are very safe in here, and the minute they walk out the door, they're at imminent risk. They're gonna go straight, they'll tell you, I'm gonna go straight to the, you can tell they're on a trip, and they're like looking at the little children in the mall. We have to document that stuff, we have to know that stuff. And it's really important that, that time does not get equated with lack of decrease in risk. Okay. So I'm going to skip over some of this, that the SPGA basis of the treatment plan, right? So whatever the risk is, that's what we put into the treatment plan, and that's what treatment team discussions should kind of focus on. I want to talk real quickly about these risk assessment instruments. So I talked a little bit before about unstructured clinical judgment. It's like that gut basis, like my clinical opinion, or this is what I think. Adding structure, adding checklists. So this is not just in medicine. We know this is true across all industries, that adding in, basically, we were talking about ChatGPT making better decisions than us. We don't like that. But the truth of the matter is sometimes when there's a dispassionate kind of checklist, it does better. So if you're going to fly an airplane pilots have to go through check. We want to do the same thing with violence risk. So even though we know it, going through it in a systematic way improves decision making. And so there are a couple types of ways to make structured. So just the data on unstructured clinical judgment is that it's associated with significantly more errors, both significantly more future violence or false errors. And also sometimes for some people, particularly patients that are like unlikable to some people, people overinflate their risk. So there was a guy in Texas called Dr. Death who testified for many years that this client was 100% likely to go out and kill again or go out and hurt people again with no substantiated basis for those opinions. So it can go either way. That, you know, in other words, we can be can have false positives or false negatives in terms of future violence, but it's much greater chance that you're going to make those errors if you're using an unstructured approach. There's very little consistency evaluator to evaluator if you're using an unstructured approach, and it's harder to articulate your decision making. Okay, I already talked about all of these. The only thing I didn't mention before is there's a few myths. One is that self-report is actually indicative of much of anything. So if someone says, I'm not going to hurt someone again, that's nice that they say that. They should say that. In the reverse, it's true. If somebody says, I'm going to go out and kill someone, we take that seriously. But just because someone says, I'm not going to burn the house down again, that doesn't mean they're not going to burn the house down again. We need other pieces of information for that. I want to just talk that there's been this thing that we see, which is if you do get people here who are very little diagnosis except for antisocial personality disorder, jail patients that come over here. And what happens in most places in New York, if someone comes over and you evaluate them, there's no mental illness, they get kicked right back to jail. Here, a lot of times the charges get dropped. You're a detainer, you get stuck with them, and now you've got this person in your system who really isn't a mental health patient. Okay. And so what we've seen some people say is this is not, they shouldn't be here, which I don't disagree with, but so we'll discharge them. But the problem with that is, yeah, they didn't come in the door the appropriate way. Maybe they shouldn't be here, but once they're here, if you see a personality disorder and risk, it's really hard. You then still have an obligation for what to do to get them out the other side. So from a systems point of view, what we advocate is not so much just discharge and let them go harm people. It's basically to do a better job of not letting them in the first place, to work on a systems level with the jails and the prisons at a meta level to block people who are inappropriate admissions. If you guys turned around detainers who shouldn't be there and sent them back and were able to send them back, your beds flow would be much, much better. So, you know, I know that sounds pie in the sky, but that's the long-term goal. In the short term, if you get someone like that, the best thing you can do is at least articulate the risk. So even if you can't control it and somebody, because we can't keep someone if they're dangerous and not mentally ill. So some of them have a little bit of both or enough of both. Many of them, their illness is substance abuse, which in many states is not going to be criteria for civil commitment, but in New Jersey seems to be in many cases. So you're a little different, you're outliers in some ways. So how you deal with a patient like that, getting them out the door is a little different, but at least we want to articulate, but we don't want to say, well, because they're a jail person, they should just go back. Because we do have the obligation to assess the risk. Yes.
Dr. Gilliard, I've had issues where the patient is competent. I've gone and testified and said, this patient is competent. You can remand them back to jail, take them back, and they actually push back and they say, no, we're gonna give you an assessment. I had one where the judge said, you're arguing with me, because I said to her, she said, I'm gonna have to come back in September. And this was in April. So she said, I'm gonna ask you to come back in 6 months and tell me, do another assessment. I said, I can assure you my assessment at that time probably will be the same, because I'm saying that this patient is competent. He's been with me for this long. And if he's competent now, I don't see the reason to take him back and keep him at TPH.
Right.
And she said, no, I have to give you another 6-month review. At that time, I'll assess. So the patient is still with us, and she did not take him back. We can't do anything.
No, you
It's an
can't.
IST.
You can't.
So we're basically back with him, and the judge said, if you have any issues, you need to kind of sort of, go about it, like send a written statement or something like that, but that's my decision and I'm gonna stick with it.
Yeah.
So what are we doing in that sense?
So in that sense, I think you're right. You don't have a choice. You're stuck with the patient, but it is a violation of that patient's civil rights. So I would be giving the patients, like, patient is not supposed to be in the hospital. And so it may be that their lawyers are arguing this for one reason or another, but you require judicial education in that instance, because that's really a dereliction of duty, right? Like the person, if they're fit, they're supposed to be going back to jail. That is just basic, simple 101 legal. So in many places, like, there's judicial. So I had lots of great comments in the break about, I'm teaching you about, like, in the perfect world, in the academic world, I'm an academic, right? That the law says this and that the principles that get weighed are this, but then when you have a judge that kind of doesn't follow the way the law is supposed to be, what are you supposed to do? So, my answer to that is that we do the very best we can based on forensic principles and articulating those. And what ends up happening in most places is that when those things are not followed, eventually there's either kind of a sentinel event or a tragedy that we were hoping wouldn't happen, but that happens, and then that kind of starts more dialogue. The other thing is that sometimes just tenacity of education, little by little by little. My husband's a psychiatrist, and he testified once in New Jersey at a case. It was a case about someone who was about to be discharged, and the judge, the psychiatrist who was in the emergency room, didn't want to, wanted to discharge. And I believe it, I don't even remember the details of the case. I think it was an IOC case, but he talked about, in his testimony, he talked about all the reasons why the client was dangerous, right? And in the short term, and met the statute. And he talked very specifically about risk factors, and he introduced the judge to the HCR 20. My logic, and here's why I'm doing this. These are the factors that have been shown in the literature. And the judge is like, I've never heard about this. I've never heard this before. This is so helpful. Okay, so I'm not saying every judge is going to be open to it, but the fact is, if you kind of raise the bar, that it moves the needle little bits of time. We're doing our best as well to kind of do it at a more, a conference type of thing, a think tank with all of the kind of with people, with the medical schools, with the residency programs. There's some residents here and forensic residents. But otherwise, you just kind of maintain the principles. And whenever there's something that really flies in the face of this stuff, it's documenting and sending that to as many people as you can. So I know that I'm talking about treatment under objection, IMAR. And what I'm hearing is that sometimes you can have a patient where you can clearly articulate the risk. Like this person, tried to poison their sister because they thought she was trying to kill her. They have all the same delusions. They believe that they would do this, and they won't take medicine. And sometimes the IMAR committee is saying things like, well, they're not doing anything right now. They're not dangerous right now. we know that is kind of, it's not just a problem for you, it's a problem for the patient. Because if we allow that patient to discharge and do the same thing, that's kind of harming the patient and the community. So it's articulating the argument that we are obligated to treat the dangerousness. That is the basis by which this patient came in. His dangerousness is still sky high. He has the delusions that made him poison his sister. Nothing has changed. Here, I'm proposing this medicine because it has a likelihood to change that. And we're asking for treatment over objection. And we get that in other states, and we can get that sometimes. Sometimes I think when you get shot down enough, you're like, oh, well, fine, I'm not going to even make that. So make those arguments. And over time, document those things and talk to your supervisors and talk to the Dr. Feibush and to, you know, the administration, because those are the things that, because ultimately you're the psychiatrist on the case. And if you can't get the ability to treat them, it really hampers you, and it keeps more patients in your system than need to be. Those are the quick fixes, right? Unless they're treatment resistant psychosis, sometimes we get people, we could fix that person and move them to a less secure setting right away with treatment over objection. So it clogs your system up. It keeps violence high. It keeps more people in. It keeps beds problematic. And then, you know, you've got the problem of the patients that are violent and regional and need to come back. So it really is a long-term change that needs to happen. But articulating the risk is important. And I guess I'm a little like, I hear and I'm humbled by the fact that you guys can do the best work and still sometimes be thwarted by a system that is really problematic, but just kind of keep at it. So let's talk a little bit about structured professional judgment instruments versus unstructured clinical judgment and actuarials. So I don't know what happened to my slide. I had another slide, but I guess it didn't make it into this slide set. But in terms of using structured judgments, just the one. Yeah, we took out the actuarials, but there's a couple different ways you can make evidence-based risk decisions. Okay, so actuarials are things like the VRAG or the static 99. Okay, so everybody knows those tools. So these are kind of checklists that use variables that have been shown in the literature to be predictive of violence. And they are very good and they're very accurate, and they're much better than clinical judgment at predicting who's going to be violent in the future. The problem with them is that they don't change. Static 99 means it's static. It's not changing. So if you are a very high risk person and we use your past behavior to predict who's going to be violent in the future, what it does is it doesn't distinguish between a person who's been responsive to treatment and a person who's not been responsive to treatment. So for that reason, for your corner of the world in the mental health system right now, treating patients, you want a measure that is responsive to dynamic factors to change. And so that's why we've recommended structured professional judgment. But I want to be clear, there's nothing wrong with actuarial tools. They're very good, they work. We sometimes see risk reports where people confound them and they use both in the same report. So they'll have a static 99, but then they'll do a structured, an HCR and say, but the dynamic factors show he's been responsive to treatment, so he's better. And the only problem with that is that you've invalidated your static 99. In other words, you don't have the right to change that. There's no mechanism to change it. So you kind of shouldn't be using it except to say, hey, it's documented history, which you could do without it. If that makes sense. So you're not permitted to change a risk formulation with a static instrument. So SPJ, structured professional judgment tools like the HCR, like the SARA, like the START, what else? The RSP. These are tools that use historical variables that have been shown to be associated with future violence, but they also use dynamic or changeable ones, like your response to treatment. Do you have a good treatment relationship with somebody? Are you compliant with treatment? Has your cognitive state changed? In other words, if you were psychotic when you did something and now you're well controlled on medicine and you have good insight into what happened, you killed a child while you were psychotic, either you need medicine or you don't now, but you're no longer psychotic, your risk has gone down. And we can demonstrate that with a structured professional judgment tool. we kind of, and all that does is it tells us, it doesn't give a score. It's not summative. All it does is it says, consider these variables. And it lets you consider the variables that the literature knows is predictive of future violence. But what it also does is it lets you add in any variables that occur so infrequently that they wouldn't make a tool. In other words, if I assessed 1,000 people, and let's say I had a patient once that her spirituality was tied into her psychosis in a way. And so that's a very relevant variable for her, like what her spiritual beliefs were at any given time. She was very spiritual before she got psychotic, then she got psychotic and it all got mixed together. That's not going to make the list, like what's your spirituality, but for her, it was very important. So I could put that in. So you can pull up any variable that's kind of a low base rate. Let's say you had a person with a genetic abnormality that kind of somehow predisposed them to some sort of impulsivity or violence, right? It would probably be captured in impulsivity, but it might be something else you add in. So SPJ gives you, the rater, much more ability to use clinical wisdom. Okay, but what it does is it makes sure that you use specific risk factors, that you consider certain things. And we've done training on this. All of you guys supposedly went to mandated training, but I know some people missed it, on how to actually use the HCR. So we're going to do it. If we have time, we'll do a little case at the end where we just talk about, the whole idea is to say, what are the risk factors? And then to say, let's say someone's leaving Anne Klein and they're going to a regional hospital. What SPJ asks you to do is say, what are the factors that produced violence in the past and that are likely to produce violence in the present? And you may have like, hey, none at Anne Klein because it's so structured and we've got them under control here. When we change the environment, how are those same risk variables going to behave? So if there's less supervision, if there's no ability to seclude, if somebody does get psychotic or aggressive, how is that likely to change? And so what we do is we imagine the client in a different setting, and we call that scenario planning. We say, given the variables we know, what is likely to happen in this new setting? And we play that out, and that is the formulation. These are the variables that are important. If they were to get access to drugs on a unit, like they are very likely to use them and they are very likely to become aggressive. This is a person who uses cocaine and gets aggressive when he uses cocaine or something like that. All right, but you can use your clinical expertise. You can talk about patterns, right? You can look at patterns of behavior. If you have somebody, this is their 5th admission, like you were saying, like we can talk about the patterns in the past. The risk factors have anchors and they're clearly defined. We find oftentimes that people aren't following the anchors. They're kind of like just gut doing things. So you want to always, even if I've been doing this 10 years, you pretty much go through the manual every time you code one of these things to make sure that you're staying within the parameters of how the tool was designed. The other thing is that it's not, you can have somebody that has 15 risk factors or 2. And obviously, the more you have, that's not a good thing, right? Your risk goes up, but you could be just as dangerous if you only had 1 risk factor, right? So maybe you just have psychosis and nothing else. You're not antisocial, but it still might be enough. So we can weigh these things differently, right? So we want to think about, and not all the variables are internal. There are things like access to weapons, right? Is someone going to have access to weapons? Are they going to have access to things that they can use to harm them? So all of these can be put into SPJ tools. All right. For you guys, one important piece of this is that it establishes your baseline for treatment and your baseline risk. And so we're going to then say, have we decreased this over time? Now, in order to put more structure, what SPJ does is it asks you to consider these things. Like, let's say the person had psychotic symptoms. It doesn't necessarily, you're using your imagination to talk about the relationship between those. So how many of our patients have substance abuse, non-compliance with medication, and increase in psychotic symptoms, right? What's the order of those? What happens if you want someone not to decompensate? Do they go out and use substances and then they stop using their medication, right? In which case we really want substance abuse treatment is very important. Or do we have somebody who become psychotic because they're disorganized and they can't. I had a patient who was an IST patient. She became psychotic because her hearing was very poor and she wouldn't hear Medline calls in jail. She was totally willing to be compliant. If you went up to her and said, you know, here's your medicine, she'd thank you, right? But she just, without enough structure, she wouldn't remember to take her medicine or she wouldn't hear when it was given to her. So she would do great in a supported group home where somebody's going to actually deliver the medicine, but self-administered, she'd be psychotic within a month. So that is scenario planning. And so if you're discharging a patient like that, you need to know the level of details. So the way we figure that out is we actually go back and figure out as the best we can, get the client to tell us about the scenario. We get them to tell us about the crime. And I know this sounds really silly, to me at least. I've done consults in your system where I talked about someone who did a crime while really psychotic, and I'll say, okay, so what do they say about the incidents leading up to this? When did they become psychotic? We want collateral information from family members, but what I've been told sometimes is that upsets them, so we don't ask them about that. Okay, so I want to be really clear, that's not okay. It is our job to get the information, to push them to talk about things they don't want to talk about. Even when someone's better, part of the stress of being able to manage having done something like that in the past is, can you think about it? Can you talk about it? Can you plan your own risks? Can you anticipate? Do you know what your symptoms are going to be if you start to get a little rumbling in your head or you start to have some symptoms? Can you anticipate that? So it's really important that we don't fragilize patients and that we kind of train everybody in our system to do that. And behavioral analysis, getting the actual story from the patient, what happened moment to moment, to the best of their recollection. They have big gaps. Sometimes they're going to remember nothing, but many times there's lots of information that when you talk to the patient, you can get that is not in your charts, that is not, and it's very helpful for knowing risk. It's very helpful about in terms of prioritizing. What's the story of how the risk factors come together to produce something? It's not just ticking them off and saying we're addressing them. It's what's the relationship? What's the story? You're telling the story of how someone went from being stable to unstable. And the easiest one is off meds, but some of ours are much more complicated than that. They're not that simple. And so that's what you're hoping to do using SPJ, is to tell the story. So the SPJ tells us what variables are important, but then telling the story has to come from clinical information you gather from talking to the patient and collaterals and using the discovery and everything else you can to piece together the situation. I'm going to give you one little story quickly. I evaluated a guy in forensic hospital who they said was demented, and he had AIDS. And the initial instant offense was a sex offense. And that was because he went into someone's room in a rehab nursing center. And he took a patient, a woman, out of her bed, and someone came in while he was like holding this patient against the wall. So they said that he was attempting sexual assault and that was his charge, and he got NGR, IST. I don't know whether he was IST or NGRI, but at any event, he was, in a forensic hospital for a long period of time. And so the question was, could he be released? What was the thing? And we actually went back and got the records, right? And kind of, I asked him about what happened. I said, well, what did you do? What were you thinking? How did you go in her room? I don't know. I just wandered out of my room and I picked her up. What were you doing? I just wanted to move her. Asked him, did extensive sex abuse history? No history, no deviant attractions, no violence, no nothing. Go back, look at the labs. It turns out he had toxoplasmosis at the time that he moved this woman. He was delirious and he had like a lot of kind of delirium, waxing and waning delirium. At the time the psychologist tested him, he was delirious. So he looked like he was demented on a dementia rating scale, but I then retested him doing dementia rating, no dementia, and no more delirium. The toxoplasmosis was treated. This guy had no risk. Like, he was totally able to go to a nursing home, but he wasn't a sex offender. And it was only because I kind of asked him the story. I'm like, this doesn't add up. Like, why was he doing this? What's going on? Get all the collateral information, get the labs, get the information. So and you can't trust what's been written before, right? You have to kind of get all the information yourself when you're looking at this stuff. So getting the story, the behavioral story from the client and getting all the collaterals is really, really part of SPJ. Okay, so some of the problems we saw in your system was no records, right? You guys can't get records when you need to get records. We're working on that. Misuse of tools by not adhering to coding schemes. So people, I saw a sex offender evaluation the other day where the person said there was no risk. And we asked about something and they said, well, I didn't ask them that. It's not in evidence. I didn't see it right now, right here. That's not the appropriate use of an SVP or a sexual violence risk, the tool that he was using. Sometimes no collaterals or sometimes using irrelevant things and kind of making them seem like they're right. So putting something in that is really not a relevant variable is also one of the ways in which you can kind of mess things up. Implicit bias often enters these, so it's not like you are intending to do this. People underrate violence in women and they overrate violence in men as a general rule. So you don't want to miss significant violence risk in female patients. And there's other kinds of biases that we have. Okay, so it's someone's size and how they look. That does go to how much damage they can do, but we don't want to perceive race is another way in which we can see differences. So that's another reason for having someone objective do it. And even somebody who might not even know the patient, look at just the materials without seeing the patient. Okay. A lot of times there's good information, but it's not documented and it's not shared with the team. So that's a problem. The biggest problem I see across the board is the failure to distinguish behavior in here with out in the community or with a less restrictive setting, right? In other words, you're doing a risk assessment for the new place someone's going, not for where they are. You do not do a risk assessment on where they are. You do it, its risk assessment tool is used to talk about where they're going next when you're making a decision. And if you don't know that new setting, you have to ask people about it. One of the things is we think that a AAA group home sounds very secure, right? It's no different than any other group home in your state. A forensic group home sounds secure, right? It just means they take forensic patients in your state. It doesn't have any added security or structure over any other group home. So just know that when you're making your recommendations. And the other biggest thing is this idea, we're going to talk about imminent risk. There's this belief that the statute is talking about imminent risk. If you have an NGRI patient, it is not imminent risk, is not the decision, the standard. And we're going to look at what it is. I think, I'm not sure if it's me or Dr. Jackson that's talking about it. Just, it's him. So I'll say it. But it's really about risk in the reasonable future. And you're able to take into account a person's past history and their patterns in your decision-making to the judge, whether the judge knows that or not. You can pull out the statute and show it because that is the decision you're making with an NGRI patient. It is not the same as civil commitment standard, unless the patient gets converted and is a civil patient. Does that make sense? Okay, so I just want to talk about the risk assessments in your state are completed by psychologists or psychiatrists using the SPJ. Right now, the main tool you're using, if you don't have a specialized problem like fire setting, stalking, or sexual offense, is the HCR. It's your global violence risk check tool. There is a note now. So rather than a 10-page report that the psychologists have to prepare that nobody reads, we have kind of a brief note. And the most important thing to pay attention to is the last page where it says formulation. It's these are the risk factors and how the relationships among them. Here's what's likely to happen. And here's the factors that can mitigate them. And if they can be mitigated successfully in the less restrictive setting, great, they can go to the less restrictive setting. If they can't, then that leads you to believe the decision should be no. If you are asked to discharge someone and you don't agree, your language can say, these are the things that would make the person safe. However, it's unclear if risk could be mitigated sufficiently in the community to prevent violence. Let the judge be the one to say, well, I think they should be discharged. And then that is on the judge, not on you. You didn't say they could go. You said the risk factors don't line up in a way that makes this person eligible to go. But if you want to do it, like, it's unclear if they can be managed. And that's the information you give to the trier of fact. Now, I've spent most of the day talking about keeping violent patients in the hospital. And I don't want you to think that that's the only reason we do risk assessment, because it's equally important that you're able to document change in patients who should be moving to less restrictive settings, right? And so we had a patient, actually a TPH patient, who was very violent, self-harming, had either burned himself chemically or set fire to himself, and had harmed a pregnant staff member, like really bad on paper in terms of like, if you're going to send him to a group home, he's done this, 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 and this. And so the discharge summary looked like that, his litany of past offenses. Meanwhile, this person had done a year of treatment, had managed, learned all kinds of emotion regulation, coping skills, super insightful, really worked hard, and had demonstrated change. So that wasn't in the scenarios. He could tell you what he was going to do if he got stressed, who he was going to call. All he said, none of that was in there. So that should go in a risk assessment too. Like if a risk assessment, if someone's documented risk has decreased, be very descriptive in terms of how they have decreased. What specifics, not just he had substance abuse treatment. He was in this type of treatment. He understands his drugs of choice. He understands why he did it. He's committed to this. He's done this, how you've tested them. All those kinds of things should go in the risk assessment report, in the formulation and the mitigation. And that is equally as important as keeping violent patients in the hospital, is letting patients who have made progress move through the system. Okay, so you guys, if you're not doing, you can actually do the risk assessment yourself, or if you're a consumer of it, you just want to kind of basically, this is a bad slide. It wasn't supposed to be like this. You can basically read that summary at the end, and it just gives the logic of the risk, what we call the forensic risk formulation, and the scenario planning. Under these conditions, it would get worse. Under these conditions, this person's risk picture would get better. And that should be the way that your team thinks about risk and the way that you can testify about these patients. So if you have more questions about the HCR, the trainings are online that you can access anytime you want. We can get you the links at the end, and so you can kind of review that. You want to educate and bring up your teams. The psychologists and psychiatrists are the experts on this. You want to educate and bring up your teams to understand and to have the basis of your discussions. Risk should always be present. We should hear the words violence and risk for these patients, not just he's doing well or he's taking his medicine. Talk about symptoms, not just whether he's compliant. Okay, they are sometimes together, but sometimes not. So I'm going to turn it over to Dr. Jackson. He's going to talk about your written reports, and a lot of this came from Don Dunphy, and some of these things are going to seem a little silly, but these are things that he's seen in the system that judges have complained about. So this is kind of how to work on your report writing and testimony. Michelle.
Kelly, I have one question.
Oh, yeah.
I just have one question.
Yes.
So I just wanted to see what your thoughts on some of the scenarios that we face. For example, we have a patient who is fully compensated. Not enough legal or clinical grounds to keep them committed in the hospital, and they have a capacity to make decisions for themselves. On the contrary, the risk assessment has some other recommendations. For example, patient wants to go and to be discharged to their loved ones or their family member, while the risk assessment is making a recommendation otherwise. And the scenario is the patient is fully compensated and has a capacity to make decisions. And we want to make sure we keep patient motivated post-discharge and stay in the community. So I was just wondering, how would you address that situation? Keeping patients' autonomy and their rights in context of the recovery-based model.
So wait, if I understand, the risk assessment says that home would be a dangerous place. Is that correct?
Not that, for example, it's not that precise. For example, the patient should A+ or A level housing is more appropriate.
Okay.
But on the contrary, patient is willing to go to their family member or their loved ones, and they're fully compensated. They have a capacity to make decisions. And we want to make sure they are motivated to stay out in the community.
Okay, so the question then becomes like, what would be wrong scenario planning, right? So if they go back to the family, what is likely to happen? And can you imagine a scenario where they can be in the family with supports and no tragedy happens? And if you can, great, they can make their decisions. If you can't, right? So we had a case like this where the person stabbed their mother, and the reason for stabbing their mother had nothing to do with acute psychosis. It was the mother said, you can't have any more coffee. Okay, so I can't be told what to do. And again, that's a little related to her mental illness, right? The rigidity of like, I need what I want, but it wasn't an acute psychotic symptom where she at her baseline, best treated with antipsychotic. That was when the stabbing happened. And so going home was not recommended for that reason, because the parents are gonna be setting limits and the kid's gonna have a problem with limits. And if you can't solve the limit problem, then that becomes problematic. And so then I would say, even though the girl wants to go home, as a team, like I'm probably not gonna be like endorsing that. Now, someone else can make that decision, like the judge.
The question is really, in those situations, it becomes complicated for us because patient is motivated and they have a capacity to make that decision, and the psychiatrist is in a situation, they don't have enough clinical grounds to keep them committed in the hospital. They go in front of the court, patient is made CPP, and the judge is asking this question, there's a family involved, there's a place to go. And then the question is, but SSPRC and CARP is making this recommendation. So you understand the dilemma?
I understand, I think, but the point is that you have to have a viable discharge plan, right, for CEPP. And so until you can be discharged, you're kind of in that limbo. And the viable discharge plan has to account for reasonably foreseeable violence in the short term, which is if we know that this pattern is going to repeat itself. So this scenario was exactly this case that I'm telling you about. The mother came and brought dinner to this patient, and the girl wanted beef and the mother brought chicken, and she lunged across the table and tried to hit the mother. We know that's going to happen the minute she goes home. So the question is, even though she's competent to make some decisions, she's probably not making good decisions around that. And then the question is like, does she have enough, you can get a capacity evaluation to see whether she actually can make those decisions, and you don't have to agree to it, and so the point is, like, the judge could say, discharge her anyway to home, and then you would have to. But I guess what I'm saying is you can't agree to something you don't agree with. You have to highlight why you don't agree and say, this is a problem. So you might say she could go home, but she's going to need some other supports in the home, but like the medicine isn't going to be the answer there, right?
Yeah, I guess that we also want to be mindful of patients' rights, their autonomy, and engagement in the discharge planning.
Oh, but you don't have a right to stab your mother, right? Like, you don't have a right to, you guys also have an obligation to the families. And so,
It becomes more tricky when the families are taking the responsibility also.
True.
So, in those situations, and the court, the legal system is actually siding with the families.
If you know what I mean, if everything lines up, then you might have to do it.
Yeah.
But I think the situation is where a lot of times there's a lot of confabulation of patient rights and illness. So give you one little example, patient won't sign consent to share their records, so we can't get their records. Patients like psychotic, not able to make decisions, but nobody wants, she doesn't have a guardian because she's acute, she just got admitted. Everyone's like, we can't get those records. That's ridiculous. In every other place that we know, you can make those records. So that's a misunderstanding of patient rights. She doesn't have the capacity at that moment. And you need that to treat her. You need to know her past records in order to do a good, decent job treating. So, the APA and everyone is really having this dialogue about patient rights versus safety and security. And so I just think we need to I'm not saying that these are easy decisions, but I'm saying you have to struggle with those things and articulate them, not roll over or just be like, well, patient rights. Like, we really have to line them out and say, and the other thing is, what's the outcome? If the outcome is just going to be rehospitalization, totally, we can live with that, but the outcome is gonna be death. Right? So let's say this girl, can you have the sharps locked up in the house, right? If she's gonna just punch her mom, okay, we can live with that. But if she's gonna stab her mom, she has access to weapons, that's a problem. So the discharge plan might say, if she goes home, she should have no access to any weapons or no sharps. They should be locked up. And if the mother can say, yes, I promise I will lock them up, that's a much better discharge plan than, let's just see how the family does. Make sense? So that's when we struggle with those issues, that's what we resolve at least a little better, some of those things. So.
Can I make one comment on this? So just regarding what you're saying, Dr. Ahmed, and I think discharge to the family. So I like to think like what you're getting back from CARP and I hope SSPRC too. If somebody assaulted a family member in the past, like that's, in my opinion, that's not enough to say that they can't go home again. It's got to be the assaulted somebody else in the past and risk still exists.
Right.
For these reasons. And that's what we bring to court. And then as far as the thing that the families take responsibility, if any of you have heard me say this before, that may be true, but I think it's good advice. Like, don't let the family's judgment supersede or be a substitute for your judgment. You know, just because they're saying they'll take responsibility doesn't mean that, oh, well, it'll be safe to discharge them and it's on them. You know, you have to look at those risk factors before you make a recommendation to the court. And then the court's going to do what the court's going to do. You just present that information. Thank you.
Okay, what time do we end? Noon.
Sorry.
Okay. No, that's okay.
I took those.
So in the next 20 minutes, I think we'll have some slides, but really kind of review some of your experiences in court and my experience in court. So give me my experience in court. Now, for the most part, I'm often an expert and testify either by deposition or by trial, either in malpractice cases, which is probably most common. And that means that there was some bad outcome. And was there a deviation in the standard of care? And some of that may have been violence from someone leaving the hospital. A person beat his father to death with a bar stool right after discharge, these types of things. And was there any deviation in the standard of care? And it really goes back to what's documented, what your risk assessment was at discharge. So clearly your written court reports is the basis for your opinion, but your basis of your opinion is as objective as possible, not at least Dr. Gallietta saying. The nice thing is in your system, we didn't have this in Michigan. And I also for 22 years had a forensic unit for patients that have where we taught forensic fellows and had patients that were either guilty but mentally ill, but guilty. GBMI was first in Michigan. Or they were now going to be released from their sentence, most often on parole. And I had to sign a document saying that, in my opinion, they're safe to be in the community. But I would have always thought about because my opinion, maybe as of right now, but if I was going to sign that, the discharge plan was most crucial. I rejected most discharge plans that we would get from we had a reentry program. From the reentry program, because the reentry program's goal was to get people out, and hopefully to look at recidivism, but not look at the doctor's potential liability and risk. My concern was that the patient was safe for discharge, but also my potential for risk and liability. And being often an expert to the state when there was lawsuits, because the other place where I have lawsuits is where there's patients sued a state hospital, a patient employee sued the state hospital, and I was the expert for the state hospital because the staff said they were assaulted because of poor management of risk in the hospital. So risk assessment is very important in treatment, not only for discharge, but while they're on your unit, obviously. So obviously all legal requirements, and that should be documented well. So if you had to go through SSPRC, you had to go through CARP, whatever you had to go through. But the bottom line also is that your diagnostic impressions are up to date. So I still see at times that it's not DSM-5 criteria that's used. Now we have DSM-5 TR. That doesn't change the criteria. It's text revision. But I'm assuming that we all use DSM-5 now, because obviously we're not going to use our most avoid using our most updated diagnostic system. So the judges, if they're gonna read your reports and you don't, obviously that's the problem. So the judges know your report. When I testified to my report, and that's often by what the lawyers do, not just the judges. The lawyers know my report almost better than I do because they just like study the brief. I had lots of cases. They had this case to go to trial with. And they'll basically ask you questions about your own report. And then you don't know the information in your own report. I always love it when the expert on the other side doesn't know their own report, or they don't know information that's in the record. But obviously it really takes, because what makes me most anxious in a case is when I had been rushed and they've been asked to do something and I really don't know the case that well. And if I don't know the case that well, I don't want to go and testify in front of a jury, a judge, or deposition in front of a lawyer. So reviewing the most current violent assessment risk, that's really, to me, if there's a difference of opinion, that's a problem. So that should have been resolved prior to, because what's protective for you as a psychiatrist I can speak to, it's much more difficult to show that two psychiatrists or committees and a psychiatrist violated the standard of care than me on my own. So if I'm going to go out on my own island and separate from everyone else, I really have to show very well why that's incorrect. And I certainly don't want to just use my opinion, but based on what the risks are that they're bringing out, how did we mitigate that risk? So I was actually recently asked to be the expert by Florida, because I also have practice in Florida and Michigan, was asked to be the expert for a Florida case for a person that has been another person that killed someone because they were an agent of the state, that they were being told by the state in their delusions that they are there to protect others from that people that may be dangerous, that the state has assigned them this role. So he killed someone that he thought was a danger. And he was found incompetent to stand trial. And he's been incompetent to stand trial now for 20 years. So there was a lot of records to review. And I said, this is going to take me forever. And the idea was now that the hospital wanted to convert this patient to a civil case, so there'd be no oversight now. And it's amazing to me that it took the Attorney General's office to become involved, because they said the person has done well, was on Haldol, switched to olanzapine, 30 milligrams, and doing well. What did doing well mean? They're still documenting that he's incompetent to stand trial because he still thinks he works for the government and is there to protect other people. But he hasn't been violent on his unit since he got there. He complied with his treatment. He goes to group. He's a model patient. So they're saying he's no longer a danger, and he also can now be committed. So they want him converted. So they almost want to convert him and discharge. His delusion was the same. So how much did his risk change? Didn't change at all. So the risk didn't change. And what was his treatment? If you're not changing, if someone's doing well on your unit, and if that's the goal, I'm going to live there for the rest of my life, that's fine. But to say now he's not treatable, because you cannot change his incompetent trial because he doesn't respond to treatment. That delusion is not responsive to treatment. He's had Haldol and olanzapine. Well, certainly, maybe if he had a trial of clozapine and he couldn't respond, but never had a trial of clozapine. Somebody wrote clozapine for a day. The patient said, no, I don't want it. And they said, well, that's not an option. And that was like 10 years ago. So the risk assessment's obviously the most important document I think you have to protect yourself. And also you have other committees to agree with you. I think if you disagree with the committee, is there a way to resolve that disagreement? They weren't aware of how that risk was mitigated prior to. So the response to treatment has to, if your risk assessment is in part linked to your response to treatment, how do you measure your response to treatment? So the biggest concern that I saw here was really what we call conclusionary statements. Patient's not psychotic, or patient psychotic, patient delusional. Patient psychotic, patient delusional, that's like a zillion different patients with a million different risks, right? We know that certain delusions are much greater risk than other delusions. So you have to document why he's still delusional, but not at risk, or still delusional is a risk. We've all learned, we know that persecutory delusions are much greater risk. If you went through forensic training and you heard the risk assessments for thought control override symptoms that was taught, you know, some of that is true, some is not. It's much greater than my insides are rotting out, right? You know, depending on what your delusion is, passive delusion versus active delusions. So if that's not documented, how do you know that your patient's getting better? What often we see, he hasn't been violent and he's not psychotic. And then if you looked at any measure of psychosis, he's still psychotic, but he's not actively talking about it. But if that delusion that he's no longer talking about on your unit is a significant role wherever he leaves, he's certainly at great risk. And if that patient leaves now, and it was foreseeable because that delusion was still there, or at least you didn't document that delusion had been resolved, there's clear a deviation in the standard of care. Because from a malpractice standpoint, it's the deviation in the standard of care is the first, then there was damages. So basically your judgment was already wrong if there's a lawsuit because something happened. Doesn't mean your judgment was faulty. It was wrong though. You said your judgment, the person was safe and the person wasn't safe because he actually committed a violent crime. Doesn't mean you did anything wrong, but now you got to show how you did do something wrong, because once there's a lawsuit, someone's saying you did something wrong, right? So documenting that you have some objective measure how you use violence. So I don't know what you guys use now to show progress. I was even using the domains, the DSM-5 is a nice way to look at documenting progress. You can rate that 1 to 5. If you want to use anything else is more complex. Some people say, oh, we can use the PANS. The PANS is really not meant for clinical use, 30 items. It takes a long time, but some way that you show the patient is getting better. So what's been mitigated and what's not, and what's the treatment priorities? When I get consulted here or there's cases, there's often the diagnosis that's documented is not the diagnosis that's being treated. You guys ever see that? So they said, well, they're really borderline, but we have to throw in schizophrenic. That's a whole different patient. If they're just borderline, you not keep patients with just the borderline diagnosis. Is that not? So don't throw in something that if it's not there, because it changes the treatment and it changes the risk. So this is, you know, some of this is common sense that the information in the chart should be accurate. What I heard was, well, we don't change the diagnosis because it's too long of a process. Is that still the case? So we change the diagnosis? Because I would never document a diagnosis or continue to write a diagnosis that I don't think was the diagnosis. So if you are not able to change the diagnosis too complex, you got to make it simpler. If you can now change it, that's good, because the diagnosis should lead your treatment. We know schizophrenia has different potential risks than borderline personality disorder, right? Borderline personality disorder may have greater risk than the patient with schizophrenia that's well treated. But the idea is the diagnosis has to be accurate. And every time we get a consult form, I just reviewed a consult form for later today. Inclusionary statements, patient symptoms, psychotic, delusions and hallucinations. That's really not very helpful, right? It's like, you know, I was an expert in the case, patient was discharged from the hospital because he assaulted someone about a week after treatment. And, you know, usually you can't sue a doctor for a third party, right? But we know that was established in the Tarasov case, that if there is violence that was foreseeable, you need to mitigate that risk. You need to not only alert, but protect the patient. And then every state usually has guidelines how you do that. So they documented in the chart, patient was violent in group today. Psychiatrist discharged the patient. What the whole thing was, now the patient was violent in group was a documented risk for that patient to leave. You know what violent in group today was? Somebody was walking back to the chair and the guy stuck out his foot and the guy tripped. You can't keep someone in the hospital for tripping, but once you document the patient was violent today, it created much litigation. That they should never have been discharged. So read the chart, so you can speak to someone that may document something that may be different than what your interpretation is, especially as you're setting them for discharge. Try not to use conclusionary statements, but if they would have just put the details of what happened, would have been much better. So often we read in the report, violent, assault. What was the assault? Someone was pushing the door against staff. Now, it might be assault, but it's much different punching someone versus pushing the door. So conclusionary statements aren't very helpful. And there have been reports where, and these are only coming from actual cases. So it was a report that they used actual examples. The patient, other name was in the report. There was cut and paste. You guys ever cut and paste? Well, hopefully you're cut and pasting for the same patient, but make sure that you're cut and pasting current and accurate information, right? Because there's nothing worse than carrying something forward that's not based on what's going on currently. So I actually read a report, not that it's a big problem, it's just probably a typo, but the patient was a female and it kept saying he throughout the report. So it just looks like someone didn't read the report and how accurate is the rest. When there's errors in my report, well, doctor, we've corrected 5 errors in your report. Did you spend as much time evaluating the patient as you did proofreading your report? So it never looks good when we have these types of things. So dangerous to others or property means that by reason of mental illness, so we know it's by reason of mental illness, and within the reasonably foreseeable future, not imminent. So this whole idea, it could go back 20 years that there's still foreseeable risk, right? So if it's something that's more imminent, obviously that's clear. They're violent today, predicted they may be violent tomorrow on your unit. If they haven't been violent for 10 years on an inpatient unit, hello, are you having any, to the patient, do you have any thoughts of harming anyone? No. Any risk that you think that you may harm someone? No. Are you sure? What if you were at your home? Let's say you're back in the store where you assaulted the gentleman that stepped in front of you. This was a patient that violently assaulted someone just for stepping in front of him, and he said, because of his delusion, the person was actually going to turn around and stab. That didn't work, and now he's being discharged from my unit or from a unit that I was supervising. And no one said, well, what if you were in that situation again? Well, they're probably trying to harm me. I'd kill him. I wouldn't discharge that person, right? But if I just ask him, are you at risk of harming anyone? No. You got to put them in the situation that they're going to be in. And sometimes they're very honest. Now, if they don't want it, and you can't obviously go with what they say, especially like for suicide. If they want to kill themselves, the last person they're going to tell is me, because I'm going to hopefully stop them if they're actually intent. So I got to look at all their risks. Now, if they do tell me they're actually looking for some help, that's obviously helpful. So recent behavior and recent act, threat, or serious psychiatric deterioration is obviously important, but what would their condition be? Because that all is going to be what's foreseeable. The patient that beat his father over the head with a bar stool was discharged on risperidone 2 milligrams. Usually not a therapeutic dose, but in the setting of the hospital and other things, he did okay with his delusions that people are still trying to harm him. Even documented a delusion about his father potentially. I had another patient that was her father was having sex with her through song in her head. I didn't even know what that meant until she explained it. But she was still having those songs, but otherwise she was doing great. And actually, she didn't kill her father. She had chopped his foot off with an axe, but he was trying to get away from her. So these types of risks, I think there's no requirement that we talked about imminence, reasonable foreseeable future, and all of the history. So I think much of this is what I've been talking to. I know we're out of time in a few minutes. When you go to court to testify, some of the things, it's not on this slide, but you are the person to best describe your opinion. And it's much better if your opinion follows with what other committees have said about risk. But you communicate your opinion based on facts. So delusion was the driver of violence. You know, the psychotic patients are the easiest patients because either they're still psychotic, is directly related to the violence, or they are not, or their psychosis no longer plays a role with regards to their violence. But you're the one that testifies to that. Now, some people say, well, I testified, I said they should be, and the judge did it anyways. The judge can come back and say, you did not communicate the information that the risk would be assessed by. You did a poor job describing it. They still come back to you, even though they went against your opinion. I've had testifying to put someone in the hospital and the judge let them go. So I think, oh, well, I'm free. Then they could come back and say, you didn't tell me about this, this, and this. Of course, we would have put him in the hospital. So if there's any risk that you omit, the judge made his decision based on poor information. So how well do you testify to your own facts in the chart? And many times, oh, I didn't know that. But you have to know that, right? So I think that there's been some discrepancy of what you can testify to, that if someone else is doing the risk assessment, that you're not able to testify to that. First of all, you can testify to your own opinion, and you should be able to testify what else is in the chart. Someone said they don't want to hear what SSPRC. So if I agree with them, it's now my opinion as well. And then I can say what it's based on. It's based on the HCR 20, either yes or no. And these are the risk factors, because if you agree with what's over there, it's now also your opinion, and you know the patient, and you also know what you can base it on. When you don't agree, you should really have good examples as why you don't agree and how those risks are mitigated. Because let me tell you, if it was me, if I disagree, I'm going to know that extremely well why that's no longer a risk, because I'm going to be now, like what I think what you said, now the doctor's on his own, right? And I know in Michigan, when I've been, as far as the Attorney General, I can't speak to New Jersey, but the guideline says that you are indemnified if you follow all of the procedures, regulations. And now the Attorney General says, you know, if we only covered people that followed every regulation and procedure, we wouldn't be able to represent anyone. But if it's egregious, they're not, first of all, if you commit a crime, an intentional tort, or any type of crime, you're not going to be covered. But if you have the Attorney General in most states can say that this was so egregious that we're not covering. Most common, they want to cover you because that means they're also covering themselves. But if it was so egregious, they can put it all on you, right? Especially if they file the charges, obviously they're not, because they're not going to have one side protecting you and one side charging you. But the information should be very clear to the court. You're the expert. The judge is not the expert. The judge making a decision based on your information that you provide. They want to argue I love when either anyone wants to argue my expertise when they're not an expert. I don't want to argue the law with them. I want to argue what my interpretation is as far as why this person's at risk or not. I'm less of a concern when the argument, when my opinion is they should be discharged and they want to keep them. I would certainly argue for my opinion, but I'm less concerned. I'm more concerned when they want to discharge someone that I think that should stay in the hospital. Often what I would not sign to was the discharge plan. That would keep the patient so instead of, they could maybe either in a correctional setting or they would be discharged to a hospital. So if the discharge plan was to go live in a hotel now for 2 weeks pending treatment, to go to an AFC home, that medications, they never took their own medicines for the last 5 years. And now they're going to just give them all the medicine and say they're going to take it. Even if they're on an LAI, long-acting injectable doesn't mean someone's going to be compliant. It means you're going to know if they got their injection or not. But it doesn't mean that they get to the community mental health center and get their treatment. I would say, unless this is an ACT treatment plan, I'm not signing. Someone needs to be going there and making sure they're taking their medicine. This needs to be part of an assertive community treatment plan. Well, we don't have any opening, okay, then they can't go. So you are the driver of your own opinion. So I agree with being able to use your own opinion. The question is when your opinion disagrees with someone else, that you are supporting your opinion with as objective facts as possible, because you do want to, obviously take patients' rights into account, families. But I had a patient was going to their family, everything else, it was all set, the mother, everything was great. I heard the patient on the phone. No, mom, I don't think they're trying to poison me with these medicines. Hold up. Who talked to this mother? She doesn't want the patient on medicine. She's not on medicine. She's going to harm someone every time she's come in, just because she's been off medicine. And the mom is telling you these medicines are going to poison you. Last slide, I think, is, seems like, you can look at it pretty much, read the chart and report. When you testify, take your time answering. Attorneys like to get you saying what you feel, what they try to get you to say. They usually know the answer to their question before they ask it. Take your time. If I don't know something, I often ask for the record. Doctor, you wrote da da da. Even if in my own report, let me go back and see what exactly, because they read 2 lines. Well, unfortunately, you left out the next 2 lines. Answer yes or no, please. I cannot answer that yes. They can go to the judge, or it's not a yes or no question. That would be misleading. So you have to dictate what you say, but taking the time, hearing the question, thinking about your answer maybe before you say it, and not get rushed or anxious. The more anxious you are, more likely you are to misspeak, right? You ever get anxious when you're testifying? So taking a deep breath, even doing some mindfulness if you have to at the moment, but there's not something that says you have to answer within 5 seconds or repeat the question. Sometimes I'm saying repeat the question because I'm trying to think of what I'm going to say. So I think this is all what we just said. And then I often may take the opportunity to educate the court or educate the other attorney. I love when they argue with me and they say, well, that may be your interpretation as a layperson, especially if it's another attorney, but that's not how we think of it as a medical expert or as a psychiatrist. This often may happen. They repeat what you said, but that's not what you said. Right? They say, no, that's not what I said. So what you're saying is, no, that's not what I'm saying. Right? Because they reconstruct it in the way they want to hear it. So these were kind of surprising to me, but I guess these are examples.
These were
really
exhibits from legal specialists, right? So apparently someone testified in a car while they were driving. So these are complaints that came from the judges and the legal specialists.
at least pull over, right? If you're gonna.
Asking the judge to go beyond their scope by like granting a specific level or stipulating a specific discharge plan, that's not appropriate. And that was really a disagreement on a team.
Well, how do they know the person just woke up from a nap?
I think it's in the bedroom with the head mess, I don't know. But these were true, like these were things that came from the legal specialists. I think there's another one more about. No, that was it. That link up there is the one to all of the training, right? So you all have access to all of the in-depth training, including scenario planning, how to use the HCR, what the HCR is.
Dr. Jackson, thank you, Dr. Vendetta, for this presentation. So there are issues that we deal, for example, at the community level. One of the major barriers that we have is stabilize our patients. And I'm talking about those patients who are frequent flyers to the meeting like us. So there are limited resources. You mentioned about clozapine. We are at TPH. I'm a big proponent of clozapine. We stabilize patients from clozapine, they're discharged in the community, and within few weeks they stop clozapine. So that is another problem. And there is also limitation of the actives, as you have mentioned. So I hope at some point that state comes up with our own integrated model system in the outpatient, For example, if we have our own clinics in each company, we are going to discharge our patients to our own clinics and coordinate this care with our own teams. In the long term, we can keep these patients in the community. So this is at the higher level. This is what I have seen over the years in New Jersey, why we have all these patients back and forth, and eventually it increases the violence and the crime.
It really should be part of your discharge planning process, that there's communication with the receiving team, and that this patient needs to be stay on clozapine. To discharge that or take them off clozapine, given that we've had other trials and this is what they responded was below the standard of care. If you're not able to provide clozapine, we have to come up with another discharge plan, and putting that in the plan, and that because they're putting themselves at risk if there's something obviously happens while they're off clozapine or they switch. And some will say, I know here there was an issue about using olanzapine well prep because you have to be able to discharge a place that would be willing to do it. My recommendation for one of the patients here, well, first let's get them stable here. Maybe then once they're, because olanzapine well prep could be a wonderful treatment, but not if you're going to then require that as part of outpatient. You're sending them to an outpatient setting, they won't have it. So you have to be able to, look at those risks when you're discharging someone. Because if you're discharging someone to the same place that you know is not going to cover clozapine, then that obviously has to be a different discharge plan, especially if it's a risk patient, because that patient will be at risk again. But I agree with you. We'd have people sitting on our units, not for just months, might have been a year waiting for discharge because Dr. Jackson won't sign anything. Well, I'm not going to sign something that's just going to have them back or at greater risk or put me at risk.
I can make a comment on that too. I think that Dr. Ahmed, unfortunately, the state is unlikely to get in the business of being an outpatient treatment provider. So that's probably not going to happen, but some of what you're referring to is in actually your control. The communication that the outpatient provider gets, the DOSP that you guys said, it's actually a little bit better than like what, for example, what I'm getting now with some outpatient treatments. But otherwise, I'm not getting any communication from the hospitals. And you guys have more time, as busy as it is here, you're not as busy as a community hospital. The better documentation that you send the patient out with about why you did what you did, the more likely it's going to be that that's going to get continued. So you can control that trend. I know that a couple of years ago, I did some work on, the discharge summaries. They never go out to the providers unless that's changed. I had done some work on them, but I don't think it ever got implemented. But those things, quality of your discharge summaries and getting them out to the providers in a timely fashion, you can control that. So that's something that you may want to think about going forward.
And everything is also like complex medication regimens. That is also another thing that we are discharging patients. So DID, QID dosing.
That's why we have a prior auth now that, I don't know, we haven't implemented it here in Trenton.
Yeah, we are going to be implementing.
But if you have a TID QA, you need a prior auth to say, why is someone going to get 3 to 4 times a day when they're never going to get that in the community? Because if you're discharging them on a treatment regimen that's not, then that's reason to keep them in the hospital. If that's the only thing that keeps them safe, you can't put them in the community to say they're going to be safe because no one's going to follow that.
Mostly our psychotropic drugs come in once in a day or twice a day. Very rarely it's quite QID or 3 times.
Well, unfortunately, that's not the case of how things are ordered.
A lot.
So
We still have I will be honest that we still have very, very complex regimens. And I think that as soon as the spread authorization.
or the worst thing, discharging someone on PRN psychosis. Not discharged. Well, Thorazine PRN for psychosis. Even on your unit, once they're stable, there should not be PRNs for psychosis. You should be managing that with your primary medication. Or even PRN for anxiety is really difficult if you think that you're going to release someone on a benzodiazepine that has a substance use history and you're going to tell them to take this when they're anxious. You should be creating, discontinue, treating that anxiety as a core medicine. I never, even in an outpatient setting, say, take this when you're anxious, because I'm creating an addiction and a potential risk. If it's an addicting, if you could take it if it's anxious, if it's, not a controlled substance. But I see that from primary care all the time. Take Xanax every time you get anxious. the goal is to prevent the anxiety, not to take something when you get anxious, right? All right, thank you all.
Thank you.